Hi, I'm criminal defense attorney Jody Lanier, Asheville defense lawyer. I wanted to talk briefly in this clip about something I see quite often in drug-related cases. That is police searching your home without a warrant. Now this is something I see all the time, and the thing that amazes me the most about it is how people don't realize that absent a judicially applied for and issued warrant in hand, those police can't enter your home without your consent. Now there are some exceptions we call exigencies, but if your house isn't on fire, if there isn't a suspect fleeing into your house while the police are in pursuit of them, if there aren't some unique circumstances going on, these exigencies are not going to exist. So generally it's going to be a paper warrant that allows them to search your home for contraband, or it's going to be just police knocking on your door doing what we call a knock and talk. And that's what I see a lot, and that's what I want to talk about real quick, because it's a pretty simple solution in dealing with these encounters. Knock and talks are where police are, in a lot of cases, trained well to come up to your front porch, knock on it, get you to open the door, and then begin a dialogue with you. And it becomes sort of it can be done in a couple different ways. I've seen it done several different ways, actually. The tone of the conversation usually will be the officers trying to make friends with you, trying to comfort you, make you feel trustworthy of what they're there to do, what they're trying to do. That's a tactic, and it's a very effective one. And police will use that to get your consent to enter the home and search. And you'll hear things such as, work with us, we'll work with you. We're not worried about a little of this or a little of that. If that's all it is, we're not going to make a big deal. It's almost a script. I can almost guarantee each time a client comes in and tells me that the police knocked on their door, I can guess at least a half a dozen phrases that were used in trying to gain the consent to get in. So it is a tactic. It's a thing that they learn to do, and they're very convincing and very good at it in a lot of cases. The tone can also be a little more aggressive sometimes. Open the door, I'm going to knock it down, I'll just go get a warrant and kick it in. Threats like that I've seen from time to time, unfortunately. But the reality is, if they don't have one of these exigencies, they don't have an emergency to get in, and they don't have a warrant, they need your consent because it's your home, and the Fourth Amendment protects you and your privacy in that dwelling. It's one of the highest standards the Fourth Amendment holds law enforcement to. And when they approach your door and knock on it, just because you answer and they begin a convincing dialogue with you does not mean you have to open. And I would recommend as an attorney in most cases to stay strong and deny that consent. And if they come in anyway, just make sure it's clear to them verbally that you do not grant that consent for the entry and the search. Now these situations can get very complicated very quickly when there's roommates, there's common areas, there are people who don't live in the home who answer the door and grant consent. Oftentimes an exigency that comes up when the door's not answered is the destruction of evidence may be going on. And if police have probable cause to believe there's criminal activity going on in the house, they still need a warrant or consent. But they can use exigencies such as, well, they were, as far as we could tell, getting ready to destroy some evidence in there, so we had to go on in to prevent that. That's a common one that gets used. So sometimes not answering the door may help, and it may not. You actually are under no obligation to answer the door, but you can probably imagine if they have a strong belief that contraband is within and they go to knock and you don't answer, but you're clearly stirring around behind the door in some way, they're not going to like that. So if you don't answer the door, you probably shouldn't be stirring around. But if you do answer the door, you don't have to give consent, and that's the main thing I wanted to convey. Obviously, you could speak for hours on this topic. There's volumes published and just opinion after opinion after opinion on Fourth Amendment jurisprudence, search and seizure, etc. So what you really need to do if this has happened to you, whether they got in or they didn't, or whether they seized something or they didn't, what you need to do is talk to a criminal defense attorney who will sit down with you, analyze your situation, go over the law, the state of the law in this area, and who can consult you as to what your best options are at this point. And I would be glad to be the one who does that if you so choose in the Western North Carolina, Asheville area. Thank you for your time, and I hope you enjoy my website.